Could the SEC v. Ripple lawsuit be over after the most recent developments and analysis by attorney Jeremy Hogan? Will the attorney's potential conclusions serve as the verdict? Check out this new video as soon as possible if this sounds like something that would be of interest to you. Welcome to our channel, where we discuss the most recent developments relating to XRP and the cryptocurrency industry in general. If you are watching one of our videos for the first time, we'd like to extend a special welcome to you. In order to ensure that you never miss a video, we invite you to turn on the notification feature. We are also announcing that this channel is giving away 200 XRP. To have a chance at taking part, the winner will be announced on December 31st if you simply subscribe to the channel, like this video, and comment with the hashtag XRP. The lawsuit between Ripple and the SEC appears to be nearing its conclusion because the plaintiff and defendants are now asking for summary judgment rather than a resolution. The case has come to an end because both parties have submitted substantial briefs. After the replies to the motions for summary judgment were submitted, the case is now officially before Judge Torres. In a recent video update, lawyer Jeremy Hogan, who has closely followed the litigation's development, predicts how the Ripple v. SEC case will turn out. Hogan responded to the SEC's response by saying that the SEC has given the legal system a much stronger and more convincing argument that XRP was sold as a security. By asking the court to consider all of the circumstances, including the defendant's statements, the economic reality of XRP Ripple's financial motivations, and the contractual terms for XRP sales, it has effectively utilized the cases it has successfully prosecuted, like the LB case. In response, Ripple has intensified its defense of acquisitions by acquiring the case close to the summary judgment. In its response, the company made 4 critical points that, as the SEC has failed to show, would be crucial in producing the judgment. XRP was not sold as an investment. All sales of XRP involve money. 3. XRP buyers did not share a common business practice of depending on Ripple to drive up the price of the cryptocurrency. Now that both sides have presented their closing arguments, what happens? The crypto law specialist claims that after the sale, Ripple has no further legal obligations to purchasers of XRP. Hogan bases his assertion on an amicus brief submitted by investment firm Paradigm Operations, which specializes in cryptocurrencies. He cited the work of one of his law firms in his brief. On page 2 of their brief, they reviewed 266 legal decisions involving securities violations. A thorough examination of federal law and court rulings demonstrates that neither authority supports the SEC's attempts to draw conclusions about the underlying assets from his analysis of investment contract transactions. There is some sort of discernible legal relationship between the mock issuer and the investor providing the investment capital in each of these applications where investment contracts are found. There is no ongoing legal relationship between Ripple and XRP, according to the evidence in the Ripple case. Buyers. According to Jeremy Hogan, there isn't, and the SEC hasn't dealt with that problem either. Hogan emphasized that rather than a sales contract, the law requires an investment contract. Lawyers draw attention to the fact that Ripple is selling XRP without making any other commitments legally, making this a sale of assets rather than a security. Hogan then concentrates on the second branch of the Howey test, which states that a joint venture constitutes an investment contract. Experts in crypto law say there are 3 main obstacles the SEC must overcome. First, given that Ripple has no obligations to its customers after the sale, how can any buyer reasonably expect it to raise the price of XRP? This is comparable, according to Hogan, to purchasing a Tesla and then suing Elon Musk when its value doesn't rise. The second problem the SEC has is that Ripple has submitted hundreds of affidavits from actual XRP holders through attorney John Deaton, many of whom had never even heard of Ripple when they bought XRP, he added. Last but not least, the SEC has retained an expert witness to address the question of whether Ripple's efforts have had any impact on the price of XRP. According to the expert witness's analysis, most recently in 2018, XRP price movements are based on the synchronization of the cryptocurrency markets rather than Ripple's actual business decisions, he said. So let's get to the forecasts and potential results, guys. Please remember to hit the notification button and subscribe to our channel if you want to be the first to learn about new developments involving XRP. Both parties have now submitted their final submissions, and the case between Ripple and the Securities and Exchange Commission (SEC) is almost over. It is noteworthy that during the hearing, Ripple has achieved minor victories, with the presiding judge making decisions in its favor on particular points. Surprisingly, civil legal experts think Ripple has a good chance of winning the case based on the favorable ruling. Prior to the verdict, the U.S. Attorney Jeremy Hogan in particular has speculated on potential outcomes and noted that there is a chance for both parties to prevail. He ruled that one Ripple wins in a YouTube video. In his initial prediction, Hogan said that if the summary judgment finds that XRP was not sold as a security, Ripple might prevail. According to him, the assumption behind the prediction is that Ripple owes the buyer of XRP no legal obligations. I think Ripple will win for several reasons, but the first and most likely one is that it had no legal obligation to XRP buyers. Hogan says that the sale took place after. There are no obligations after the sale. In other words, there cannot be an investment contract without an investment. He did, however, issue a warning, stating that if Ripple appeals the case, it may succeed using the legal obligation defense. Ripple loses when you rule. In his second forecast, Hogan issues a warning. Despite the general public's belief that Ripple will prevail, the company is probably going to lose. He claimed that there is a nearly 30% chance that Ripple will fail. He said that if the SEC's evidence demonstrates that Ripple used XRP sales to expand its business of facilitating cross-border payments, the judge might rule in the regulator's favor. Hogan added that Ripple will be able to weather any financial storm that may result even if it loses the case. Laying out all of the statements, emails, and YouTube videos of various Ripple employees discussing the price of XRP is one thing the SEC did well in its earlier briefs. Judge Torres had 8 years' worth of work to consider before he agreed with the SEC after reviewing all of those statements. Hogan tacked on. Hogan added that Ripple will be able to weather any financial storm that may result even if it loses the case. Third decision, a tie. Hogan even suggested that the case might end in a tie, citing a 19.1% chance that the judge won't decide in either party's favor and divide the child. Judge Torres divides the spoils and rules that while early XRP sales were classified as security sales, they eventually lost that status and became non-security sales. Added he. However, Hogan thinks the likelihood of a draw is slim given the case's implications for the overall cryptocurrency market. The attorney stated that there is always the possibility of the judge issuing an unexpected verdict, which is common in litigation. He believes that the judge must make a reasoned decision based on the evidence presented by both parties. Nobody has really given much thought to the fourth possibility. And that does take place occasionally in court cases. The official lawsuit prediction in the legal brief, according to Hogan, is that there is a 50.1% chance that Ripple will prevail and a 29.9% chance that the SEC will. Participants in the cryptocurrency market are indeed closely observing how the outcome of the case will impact the price of the native token for Ripple. XRP. It's important to remember that whenever a court ruled in favor of the blockchain company in the past, XRP has seen a small increase. The judge's decision to permit the presentation of documents pertaining to former SEC Division Director William Hinman was one of Ripple's victories. He was quoted in the documents as saying that Ethereum was a security. As soon as the court accepted the XRP using businesses and cryptocurrency industry groups' amicus briefs, Ripple surged. Investors still have faith in Ripple, and it also appears that the company is ignoring the legal problems. Experts estimate that Ripple is worth $15 billion, making it the only cryptocurrency company in the top 10 startups in the United States and the 10th largest startup overall. Additionally, both parties asked the court to set a deadline by which anyone who isn't a party to the current legal dispute must proceed in order for any part of the summary judgment to be sealed. According to the letter, both Ripple and the SEC are requesting that Judge Torres set a deadline of January 4, 2023. We've reached the end of the video, guys. If you liked it, please click like on the video. Don't forget to hit the notification bell and subscribe. I find that the YouTube algorithm is greatly aided by this. Sharing this video with as many people as you can will also help enlighten others in the same way that you have been enlightened. Let's spread the word about this, guys. Don't miss any of our content if you are a true cryptocurrency enthusiast. I'll see you tomorrow to discuss the most recent news that affects our entire community.